this is Patrick King at Miller King. At Miller King, we focus and concentrate in several different areas. There's 6 attorneys. One of the areas that we focus in on or concentrate narrowly is personal injury. And specifically, I would like to talk with you about injuries to minors. What is a minor? A minor is someone who is under the age of 18. And what is significant about that age is that a minor is not able to engage or enter into a contract. Therefore, a minor cannot enter into a settlement agreement or prosecute or pursue a wrongful death case or personal injury case or anything of that nature. So what ends up happening in a minor's case is either a family member, such as a mother or father or grandparent, may bring a claim on behalf of the minor. And what's significant about that is that the minor, again, cannot make an independent decision. Therefore, the parent or grandparent or the guardian is substituting his or her judgment for the minor. Therefore, one of the key components of a minor's personal injury case will be the seeking of court approval. And oftentimes what happens is the personal injury case will flow or proceed very naturally like any others, where the first word of advice is the minor should seek medical care and treatment. And then once medical care and treatment has been rendered and performed, and maybe all treatment's been completed, the next step will be for the lawyer, the law firm, to accumulate the records and the bills. And oftentimes one of the concerns of the parent is how are the medical bills going to be paid? Again, the medical bills should be paid through the settlement or through the proceeds after a verdict if successful. Before the minor's claim or case can be settled, court approval is necessary. There's different strategic steps to go ahead and set up a court approval process for a minor. Once a court of competent jurisdiction approves a minor's settlement, the minor does not receive the proceeds directly, but rather those funds are deposited into a restricted account with restrictions. So the goal of a minor's personal injury case is obviously for that minor to heal, get the necessary medical care and treatment, make sure that the parents or grandparents aren't liable for tens of thousands of dollars in medical bills, but that a portion, that is a significant portion or a reasonable portion, is set aside for the benefit, the exclusive benefit of a minor, whenever the minor turns age 18, sometimes beyond. So minors' cases in Illinois require careful attention to detail, following the rules, not only the rules of civil procedure, but the probate act, and making sure that the minor is protected, that everything's done in the minor's best interest. And oftentimes that requires perhaps a court of competent jurisdiction. In fact, it rarely does not require that. In fact, every time that I've handled a case, a court and a judge will be required to review the process to make sure everything that's being done is fair and in the best interest of the minor. The most common form of a minor's personal injury claim will generally involve a motor vehicle or traffic crash. It could be a medical malpractice case. It could be a premise case where a child is somewhere and either playing or walking or running and then suffers an injury as a result of a slip and fall or a premise that is a problem with the property. Also, it could be a truck accident, which is a various form of a traffic accident. It could be a truck accident, semi-tractor trailer case. But really, a minor's personal injury claim can range the different issues from medical malpractice to an automobile case. And I think the first step is for the parents to make sure that their kid receives the necessary medical care and treatment. And then once that happened, then to seek the advice of an attorney. Again, there's no obligation to hire an attorney. Here at Miller King, we handle cases on a contingency fee. That is, we handle the cases without a retainer or an advanced retainer, but rather we handle it on a percentage. Generally, it's 1/3, that's the industry standard. And we handle it in such a way that if the case is successfully resolved, that Miller King would receive a percentage. But we always keep in mind that we want to ensure that the minor receives a fair and reasonable portion of the proceeds in the best interest of the minor, which again generally will involve a court and a judge to ensure that the minor is being taken care of. So kids play sports, kids are involved in fun activities, generally physical, strenuous type activities, whether it's scouts or gymnastics or baseball or football or swimming or Girl Scouts. And so, if you believe that your child has been injured through the fault of a third party or someone at fault, then the best word of advice is to contact a lawyer or law firm and seek his or her advice as to whether or not someone can be held responsible. Here at Miller King, we take each case very seriously and we give it a careful look. And we'll be very candid with you. If there's not an ability to recover, and based upon the facts that it's just simply an accident, no one's fault, bad things happen, and sometimes kids do get hurt, then we'll be honest with you. However, if there is a situation where your child, whether son or daughter, grandchild, niece, nephew, etc., is injured, and it's through the fault or responsibility of a third party, then we are more than happy to take a look at the file and investigate it. And again, it takes research, it takes time, and it does take some patience to investigate whether or not a minor, that is a kid, was injured through the fault of someone other than their own, or more likely than not, it was the fault of somebody else that could be held legally responsible or liable.